Imagine a real estate scenario where the usual process of detailing every aspect of a property seems to shift. What are the specific situations where a seller might not be required to provide a full property condition disclosure statement? Property condition disclosure waivers typically apply in a select group of transactions where the seller has no direct personal knowledge of the property's history or physical condition. This means they are not a common occurrence in standard residential home sales and are subject to state and local regulations. The fundamental reason for these waivers stems from the seller's inability to provide accurate information. If a seller has never lived in the home, they cannot reasonably be expected to disclose defects or issues they have no knowledge of. This principle protects sellers from liability when they genuinely lack first-hand experience with the property. In such cases, the buyer inherently assumes a greater responsibility for their own due diligence. These waivers commonly arise in specific types of sales. For instance, in an estate sale or probate sale, the executor or personal representative selling the property for a deceased owner often has no direct knowledge of its condition. Similarly, bank-owned properties, also known as REO or real estate owned, or properties being sold in foreclosure fall into this category because the lender never occupied the home. Another key situation is new construction homes being sold by the builder for the very first time. Here, the builder typically provides their own warranties and disclosures about materials and workmanship, which are distinct from a typical property condition disclosure. Government entities selling surplus properties also frequently qualify for such waivers. It is crucial to understand that, even when a disclosure waiver applies, it does not absolve a seller or their agent from disclosing known material facts that could affect the property's value or desirability. This is often referred to as a latent defect. For example, if a seller is aware of a significant structural issue or environmental hazard, they still have an obligation to disclose it, regardless of a general waiver. This distinction is vital for maintaining transparency and ethical practices in real estate transactions, even in unusual circumstances. The term material fact refers to any information that a reasonable buyer would consider important in their decision to purchase the property. For real estate professionals, understanding these specific scenarios and the nuances of disclosure waivers is key to guiding clients effectively. It allows you to set proper expectations for buyers regarding their due diligence and helps sellers navigate transactions where their personal knowledge is limited. This knowledge not only protects your clients, but also reinforces your role as a trusted advisor in complex real estate dealings.